Today we are going to talk about how far can the government go digging into your whereabouts using technology and not getting a warrant, right? Because usually when they start snooping around, especially when it comes to technology, the government's got to go get a warrant. So we have this sordid tale of a case today in the United States versus Mapson. In Mapson, there's three sisters charged, right? And Teresa, Charisse, and Elisa are charged with trying to murder this guy. Now, the reason they're trying to kill this guy, apparently, is these three sisters, the Mapson sisters, live in, say, Arizona. And Teresa has a child with a guy here in Winter Park, about 2 miles from my office, right? And this guy got 6 weeks of unsupervised visitation with his child. The couple decides to meet in the middle in a small town in Alabama where there are no stoplights and there's just a diner and a gas station. And they agree to meet there. And they're texting each other along the way. And the woman charged is like, oh, I have my child and she's car sick. It's going to be a couple hours and this and that. It's been a couple hours late. He's sitting in his car waiting. Gunshots go off. Bam, bam, bam. His car gets hit. He actually gets hit in the arm. Now, he doesn't tell Teresa Mapson, the defendant here, that he got shot. He texts her, can you just meet me at the hospital? I've had a minor incident. Just meet me at the hospital. Eventually, she responds, oh, I just went all the way to Florida, et cetera, et cetera. Now, the cops start investigating this shooting, and they question her, and she's like, I was in Florida the whole time with my sisters. Well, okay, there's a problem with that. Number one, her cell phone actually went towards the diner with the cell maps. But number two, the big problem was the ALPR data. Now, ALPRs come up in criminal defense every now and then, but for the rest of you, you probably don't know these things. They are automatic license plate readers. So this woman claims that she never went to this small town in Alabama, except for the fact that the ALPR data has pictures of her license plate on I-75, then on I-20 in Georgia, then on I-20 in Alabama. I mean, her plate is red all the way to this small town where the shooting was, where she claims she never was. Now, when she got convicted and sent to prison, she filed this appeal and said, guess what? I mean, she's right. They did not get a warrant to get the ALPR data. There was no warrant. Look, this data, by the way, is run by a couple private companies. So everywhere in the United States, cops are taking pictures, and there's stationary units that are also just taking pictures of license plates and sending the data to two companies. One's called Villagen, I think. Other one's called LSAG. And these two private companies keep track of this data. So a cop can reach out in an investigation and say, do you have any data on this particular tag? They did it of Teresa Mapson's tag. And of course, they found her where she said she wasn't. They found her car traveling towards the shooting site. And she objected to the admission of that data because they never got a warrant for that data. Now, I'm not going to give you an answer to this question. Is this a violation of Miss Mapson's Fourth Amendment rights to be free of unreasonable searches and seizures because the government never got a warrant for this data? Well, I want you to think about what this data is, folks. It is your car is on a public highway and it's just getting pictures are just taken of your car, of your license plate while you're on a public highway, and that those pictures are kept and data's run your car that's on a public street. They're not keeping track of your car in a garage. They're not keeping track of your car on your 100 acres of property where you're doing whatever you do on private property. These are public streets. Does this data, is it so private that it requires a warrant? And the court dodged the question. The court alluded to the fact that right around the time of this shooting, the Carpenter case was decided by our Supreme Court. This is a pretty big deal because in Carpenter, the government decided to convict somebody based on their whereabouts, and they got their whereabouts from cell phone site data, right? Historical cell phone site data. They could figure out where a defendant in Carpenter was going. And they didn't get a warrant for that evidence. And the Supreme Court said, no, your cell phone history is so private. Even the data that goes to the towers That's so private that we want the government to ask for a warrant and have a good reason to get that warrant, okay? And in this case, they dodged the question and said it was okay. They actually indicated, it's kind of interesting, there isn't any case law on these ALPR databanks. There just isn't. And they acknowledge that. They say on like page 18 of the opinion, there is very little in the case law and academic literature about whether the acquisition of ALPR data constitutes a Fourth Amendment search that requires a warrant. There's nothing out there. And guess what? They didn't make a decision either. They said it was okay in this case. The conviction for all these sisters for trying to kill this guy, the conviction stands. We don't have an answer to this question. I suspect they don't need a warrant for this, but we're going to wait for another case to rule on it. This case, they declined to rule on it.